Congratulations, Canal against United, 4-2.
Yes, Mr. de la Mare.
I appear along with Charles Morgan, Mr. Nicholas Ostrowski, George Molyneux, instructed by BDB Pitmans for the appellant, Mr. Karras, James Morici, Richard Mools, James McCreth, instructed by Pinsent the Masons for the respondents, and Mr. Hockman and Tom Kluger are for the interveners. The core issue in this case, we're all agreed, is a question of statutory construction about the interface between statute and common law rights. It's about how far the common law is swallowed up by a statutory regime. And it poses these questions. When faced with a discharge of foul water into a private watercourse, does the qualified duty of Ofwat to obtain an enforcement order under sections 18 and 94 of the Act to prevent continuation or future instances of such discharge, does that operate to oust all common law remedies connected to that discharge in circumstances other than those involving intentional or negligent breach of duties? Or do the provisos in section 117(5) and 6 and in section 186(3), read with the Act's wider provisions, notably its section 18(8), 94(4) and schedule 12, show that Parliament intended an action in nuisance or trespass to continue to be available for such a breach? Those are the questions ultimately posed by paragraph 2 of the relief granted by Mr. Justice Fancourt, the declaration upheld by the Court of Appeal. And of course, a very similar issue was considered by the House of Lords in the Marchich case, where a complete ouster was identified in an escape case, an ouster later qualified by the Dobson line of case law. Now, while the issues in this case arise in the context of discharges into a large industrial canal, from United Utilities' perspective, no doubt the perfect backdrop against which to argue its case for an implied immunity, the principles that will be established in answering this question will apply to every sewerage undertaker's discharge of sewage into every river, canal, lake and pond in England and Wales, be it the Manchester Ship Canal, Lake Windermere, the rivers Test at Itchen, the Wye or the Trent. And this court does not need to be told how timely consideration of this important issue is. The evidence filed by the Environmental Law Foundation helpfully summarises the escalating problem of sewage from rivers and other waters, which is, of course, a current staple, daily staple of the news. Discharges are regularly occurring outside exceptional weather, and regrettably, UU appears from the EA figures helpfully exhibited to Ms Moore's statement to be amongst the most regular of the undertakers in its use of discharges from CSOs, spilling from each CSO on average about 60 times a year, or once a week. And whilst we like the weather in this country, there isn't an exceptional weather event once a week. It's this evidence as to the current implication of this case which makes the background evidence accompanying and contextualising these Part 8 proceedings, which were prepared in September 2018, a little more dated, little more than somewhat dated 4.5 years later. And in truth, this case probably boils down to whether and when water companies are entitled, under the scheme of the Act, to an extensive implied immunity to pay compensation to those whose property rights they damage when they discharge foul water. That is, UU says, the inescapable logical consequence of the House of Lords decision in Marchich, and in essence, the Court of Appeal agreed. The immunity is not absolute. UU accepts the Dobson exceptions, which mitigate some of the potential absurdities that the logical extension of Marchich to everything within the width of section 94(4)(1)(a) and B would produce. And as part of this appeal, one of the things I think you're going to have to consider is the coherence of those Dobson exceptions. Now, I've already repeatedly referred to discharges, that is, water coming from outlet pipes that form part of a sewerage system by design, whether CSOs or outfalls from wastewater treatment works. This case considers all forms of designed discharge into the canal, of which there were approximately 110. But in Marchedge, the relevant nuisance was caused by an unintended, or at least undesigned, escape of sewage into the system, or into the gardens of Mr. Marchedge and others, caused by the system backing up, a failure to invest in extending the hydraulic capacity of the relevant sewage pipes downstream of the manhole in question. Indeed, CSOs are part of this system by design, seeking to prevent such backing up by allowing volumes of water to escape in exceptional rain. Now, the potential and heavily contested significance of this distinction between discharges and escapes is this. An escape is a simple breach of the drainage duty in section 94 of the Water Industry Act. It's the only part of the Water Industry Act in play, though it's also a breach of Regulation 4 of the Urban Wastewater Treatment Regulations, which flesh out section 94, and I'll take you to in due course. But an unlawful discharge entails a further, far more specific breach. The scheme of the Act is predicated on the assumption that all potential points of discharge of treated or untreated sewage into a private watercourse or onto private land require either statutory authority or consent, whether it's voluntary consent or consent effectively obtained by compulsory purchase, without which it will constitute a trespass, or if damage to land ensues, nuisance. That was the predicate of the BWB litigation. It was also the predicate of the Manchester Ship Canal litigation in 2014, which I will call MSC1. And UU now seeks to sidestep the logical consequences of those cases by saying that even though it's acting without authority, all claims in nuisance and trespass are nevertheless ousted by the statutory scheme. Now, it's clear from this court's decision in MSC1 that there is no power, implied power, to discharge water to be found in section 94 or section 159. Instead, the only implied statutory power in relation to pre-privatisation outfalls is found by implication in section 116, the duty of continuing provision, as we call it in our case. And that is in part 4, chapter 2 of the Act. And I'm afraid one of the things you have to do is keep very, very close tabs on which part and chapter you're in. Section 116 also forms part of the relevant sewerage provisions as defined. And the consequence of finding the implied power in section 116 is that it must comply with the requirements in both section 117, 5 and 6, and indeed in 186.3. In other words, the implied power is a power to discharge only clean or cleaned water, and only so far as it doesn't constitute a nuisance. The proviso's purpose, then, is to operate as a limit or condition on the statutory authority or power of discharge. And we say, applying conventional principles of statutory construction, that where that particular limit in relation to a particular power is breached, and there is no statutory authority at all, it must follow, if this Act is to operate coherently and to make sense and to generate principled and logical conclusions, that a complaint of trespass or nuisance must lie in respect of that excess of powers. And we shall see that the immunity, as found by Mr. Justice Fancourt and the Court of Appeal, even where qualified by Dobson, operates not only when a water company is in breach of its section 94 drainage duty, but even where it is operating in breach of those powers. And the operation of that ouster argument, we suggest, is to render meaningless the limitations that those provisions are designed to impose, limitations that were designed as saving provisions for the continued operation of the common law. And what's more, what's created is a most peculiar form of immunity, since full compensation is assiduously required by the Act for all forms of damage caused by acts undertaken within the scope of authority. So the only immunity that the Act creates is an immunity for acting unlawfully. That leads to what I hope is a surely uncontestable observation. The legal effect of the provisos is necessarily front and centre in this case, in a way that they never were in Marchedge. Indeed, they weren't even cited in Marchedge, for the simple reason that in a straightforward escaped case, they had no operation. It's only when you're concerned with a discharge and an implied power under the relevant sewerage provisions that the provisos come into operation. And that leads to an important point of approach in relation to the question of statutory construction. Do you start the analysis of ouster with the particular powers and the limits that lie upon them, or do you start with the general duty and reason from that? That latter approach was the approach of the Court of Appeal, and we suggest that that is wrong in principle. The analysis should start with the particular powers, and that is how, in a case I will take you to shortly, called Piggott, in a different water context, the matter was approached. Now, I'm not going to reiterate the details of our position in relation to how the questions should be answered. You understand that our primary case is that Marchedge can be distinguished on the basis that this is an escape case and that that is capable of generating sensible and principled answers. But if we're wrong in relation to that, we don't shirk from saying that Marchedge is wrongly decided, and we don't shirk from saying that the substantial bar in persuading this court to apply its 1966 practice statement is comfortably past because of the unprincipled, incoherent, illogical and unfair results that Marchedge generates. There is a lot to get through in this extremely complicated regime, and like I hope most advocates, one has to engage in sensible shot selection, because it's certainly not possible to get through everything that is contained in the very compact and dense cases filed by both parties. So I hope you've received electronically a topic list of the areas I now intend to concentrate on. I have it in paper form if it's helpful. It's literally one sheet showing the headlines, so I don't have to read them out.
Yes, that'd be helpful.
I'm most grateful. You'll be relieved to hear there's going to be no exegesis on 19th century drainage cases or the ins and outs of pleasure gardens or sewage in Victorian England. I'm going to concentrate on what I think is the key issue in this case, which is the principles of construction for this legislation and its key provisions and how they interface. But my first topic is a very short one. It's the fact that but for the operation of the Act, there would be no doubt but that actions in nuisance or trespass potentially lay. That's the factual predicate of the Part 8 question. It's a question posed by reference to ouster. And Section 2 of UU's response to our note on the Fern case helpfully indicates it's not in dispute that but for the scheme of the Act, there's an arguable case of nuisance or trespass. But it's also important to understand, and I know members of the panel have been through this recently, the contours of the common law claim that sit in the background. Because a claim in nuisance or trespass lies even where the activity in question has received planning permission or is the subject of a careful and detailed environmental permitting regime designed to control environmental and private nuisance from activities that are otherwise polluting or nuisance them. And so much was established by the case of Barr and Biffa, starting at page 1863 of the authorities bundle, and the case of Lawrence and Fenn Tigers. And in the case of Biffa, Lord Justice Carnwath, as he then was, decided at paragraph 43 that, and it wasn't a case in which there was argument about ouster, there were two core rules. The first was that in general, even for heavily regulated or permitted activity, in order to meet a claim in nuisance arising from that activity, you had to show a defence of clear statutory authority. If there is no authority, there is no defence to the common law claim. Secondly, it was held that compliance with those detailed regimes of regulation designed specifically to control nuisance and strike balances as between the competing interests does not preempt or preclude a claim in nuisance. Permit compliance is irrelevant. Permit breach, on the other hand, may be a good indicator of nuisance activity. And that, for what it's worth, is how earlier cases involving discharges of sewage by undertakers, like Pride and Derby, analysed matters. There were two questions. Was there a nuisance? And we're not concerned with that. And if there was it authorised by the relevant statutory provisions, in which context the analysis of provisos that are designed as saving provisions were obviously central to the question of the effect of any statutory authority. Those were the only questions in Pride and Derby. But what's of particular note for our purposes is the reason why environmental permits or the grants of planning permission can't have the effect of precluding a claim in nuisance. And here I would suggest it's the speech of Lord Neuberger in the Lawrence case that is central, because in considering and approving bar, he considered it to be important that were you to give a regulatory scheme such an effect as to limit an ability to claim a nuisance, what you would in substance be doing is granting statutory authority without providing for compensation. It's paragraph 90 of his speech in Lawrence. And it was the absence of compensation.
Can you give us the page?
Yes, my lord, 2814. Now, this is what public lawyers would call the principle of legality in operation to prevent common law rights from being indirectly encroached upon by legislative development. So the argument was directed at considerations of public interest and reasonableness, but the principle of legality, the requirement for compensation if your property rights are to be intruded upon, suggested or provided the answer. And you'll also see at page 2815, 92 to 95, approval of Lord Justice Carnwath's approach in Bar and Biffer about the primacy of statutory authority. UU's problem is that they cannot plead statutory authority. Their case is that they're in breach. And they can't set up compliance with a permit condition as a bar to a claim in nuisance because Bar and Biffer says it's irrelevant. And that leads to what I hope are these important observations about the exceptional nature of the ouster and immunity in this case. The ouster or immunity sought here, flowing from the Water Industry Act, goes well beyond and operates entirely inconsistently with this strict approach to statutory authority, an approach that is applied to every other incident of regulation of waste or polluting activity. No other commercial entity handling waste in the public interest, whether or not for commercial reward, like a landfill or waste transfer station operator, no other operator gets a free pass from the law of tort, even though there's a specialist regulator sitting in the background whose views as to what may or may not be accessible are being second-guessed by the grant of the claim. And what's more, we can find no other case of a full or extensive immunity from tort being granted alone to those who are breaching their powers and thereby causing damage to property. On any analysis, the immunity conferred by Marchich in such circumstances is singular.
When people talk about the principle of legality, that's quite a modern doctrine in public law. What we're talking about here is something far older. It goes back at least to Entick and Carrington. I mean, a trespass case, but the principle's broader than that. But if you're going to interfere with a person's rights in private law, you need to be able to point to, normally, statutory authority, or in order to justify your conduct. And the argument here, as I understand it, is that although the statute hasn't taken away private rights, the scheme of the statute has rendered them unenforceable.
Well, the substance is that the rights are lost without compensation. It's the problem identified in the Fern case, to which we're going to come. But in my submission, the principle of legality is an umbrella term for a number of like doctrines of construction, all directed to ensuring that rights that are treated as fundamental by the common law, and property obviously figures preeminently in private law cases about land, aren't encroached without clear wording or necessary implication. And it's ultimately an organising label for all of these canons of construction. If one goes back to a case like Sims and looks at the cases drawn upon in Sims, they're cases exactly like Entick and Carrington, because what one is ultimately looking at is the interface between statutory regulation, whether it's prison letters or the regulation of water, and rights that are protected as fundamental at common law, property, communications with solicitors as it may be, or privilege against self-incrimination in Sims. It's the same consideration, the same argument of common law, legal or policy recurring in different contexts, but it has the same weight. And that's why topic 2, when one comes on to look at the recent case of Fern, the majority emphasised in Fern that the reason that the proper home for arguments about public interest considerations was in the law of remedy and not in the plane of liability is because to set the terrain or set the scope of liability by reference to public interest considerations itself offended against effectively the principle of legality. The passage we've cited in the Fern note in Lord Legate's speech at 121 to 122 that emphasises the fundamental integrity, the fundamental importance, the integrity of the system of property rights, that rights for property shouldn't be taken away without compensation, is, we would suggest, just another manifestation of the principle of legality.
So can I just be clear what you're saying? You're saying here we've not merely got a taking away of common law rights, we've actually got a taking away of fundamental common law rights, and that therefore requires one to apply the principle of legality, where one will need particularly clear wording in order for that right to be taken away. That's the submission.
Absolutely, absolutely. And when one then comes on to topic 3, and you look at the topics of relevance to the question of ouster, when you're looking at for things like consistency, the fact that one's dealing with the principle of legality qualifies the type or strength of inconsistency that must be found in order to displace the common law rights in question. The critical thing to take away from Fern is this court's very recent acceptance that the law of nuisance, and I would say by extension the law of trespass, is the means by which the private law protects the fundamental right. That's what Lord Legate says. Trespass is actionable per se because of the paramount importance that the law attaches to the autonomy of the landowner to control what happens on their land, whether it's beneficial in the public interest or not, whether the reasons for refusing access are arbitrary. It's that autonomy that is protected by trespass. And nuisance is obviously a tort designed to protect the value of interests in land being devalued or rendered worthless by activity that intrudes upon them and impacts upon the value attached to particular forms of exploitation, whether it's farming or fishing, recreational use, it matters not. So we say it's highly significant that this court has said that effectively those torts protect the fundamental rights in property, and considerations of public interest are to be addressed at the remedial stage, not the plane of liability. And that suggests in my submission that the proper home for the sorts of consideration that moved Lords Nichols and Hoffman in Marchich is on the remedial plane, not the plane of liability. What one should be looking for is remedial inconsistency in the scheme and asking whether or not that remedial consistency arises by reason of necessary implication. That's the test used in a principle of legality case. Now,
It can't entirely be as simple as that in this sense, can it? You say public interest issues aren't relevant at the liability stage, but we know that at the liability stage there is a statutory authority defence, which one would assume is very often reacting to a public interest.
yes.
So it can't be just we don't look at public interest issues at all, can it, at the liability stage?
Of course not, my lord, but what that tells us is that the only place that you look at public interest issues is in the identification of a defence of statutory authority. It's the defence of statutory authority that constitute Parliament's answer to the question as to whether or not there should be liability or not. And that's why the rule, bar Marchich, in every single case, is if there is no statutory authority, it is a tort.
If you think about Ensign and Carrington, you have the Home Secretary's officers bursting into somebody's home, ransacking the drawers.
Yes.
There's no issue about whether there was a public interest. The argument was, well, the Home Secretary's been doing this for a very long time, and the Home Secretary is acting in the public interest, and the Chief Justice, of course, wasn't interested in that, and said, well, that's all very well, but you can't set foot on somebody else's property without a statutory warrant.
Yes.
And
Well, with respect, my lord, there were two interests in play in Ensign and Carrington. There was the right of property, and actually, also very importantly, the privacy in the papers in question. That was the interest that were being protected by the common law. And the vice in Ensign and Carrington was the vice of a general warrant, which the court effectively concluded was insufficient to properly confer statutory authority for the action in question. So, with respect, it makes the point I made to my Lord Burrows, that one looks on the plane of authority for the action that would otherwise be tortious. And that's why we police warrants and the terms of warrants as carefully as we do, because it is the warrant, under the scheme of warrant granting, that exceptionally confers the statutory authority to do that which would otherwise be tortious.
yeah, but it's accepted in this case, isn't it, that the discharges we're concerned with are not authorised by statute.
Yes, and that's what makes the ouster so very peculiar. It's that which generates the incoherence, because generally, in the law, you expect the law on ouster to march in step with the law on statutory authority and the law on compensation. The usual scheme for legislation like this is you get a power, let's say a pipe-laying power. That confers authority to go onto someone's land and lay pipe on it, whether they consent or not, to do something that would otherwise be tortious. It's accompanied by a statutory right, invariably, of compensation of the kind that we see in Schedule 12, Paras 1 to 3 of this Act. And the consequence of the statutory authority and the conferral of a right of compensation is the ouster of claims in common law. You can't make a claim, instead your remedy lies exclusively for the compensation provided for the lawful exercise of the power in question. So ouster, statutory authority and compensation all marry up. And the peculiarity in this case, quite exceptionally, is that there is no right of compensation and there is no right of statutory authority, and yet it said the right to claim is ousted. Now, one of the striking features I would suggest about Marchich is that even though it's a case, so far as the claims of trespass are concerned, or nuisance are concerned, there is no consideration at all of the principle of legality or of the common law's protection of fundamental right to property.
Can I bring you back to what I perceive to be your argument about public interest affecting the remedy? And are you suggesting that at a stage of deciding on the remedy, that one, in effect, an injunction is going to be impossible to obtain?
I'm suggesting my primary position is that in most cases it will be extremely difficult to obtain an injunction for precisely the reasons identified by Lords Hoffman and Nichols, because the court will be extremely chary by means of an injunction to second guess that which is happening through the enforcement process or by way of a statutory undertaking. And I'm also going to further suggest that Dobson, in fact, is incoherent in principle, but entirely sensible in result, because it's the types of case identified in Dobson that are the strongest candidates for an exception to that general principle against relief. Why? Because negligence in the Dobson sense, which is Allen and Gulf oil nuisance, failing to take the steps you could reasonably take to keep the intrusion to a minimum, is a matter under the control of the undertaker. You immediately see that if they're not taking reasonable steps that they could to limit the amount of discharge, that doesn't call into operation the kind of policy questions that are raised more generally by the grant of injunctive relief.
You formulated the claim then therefore, on the basis of damages. If the purpose of the Water Act is to ensure that we have clean waters in our rivers, is there any compulsion on your client to spend the money on making sure the water is clean?
There's no compulsion on my client to spend the money on making sure the water is clean, but that's because the compensation that will be payable for the damage to their property. And once they're compensated for the damage to their property, they can spend the money in question as they choose.
Doesn't that mean that the distinction you're trying to draw between an injunctive remedy and a damages remedy is illusory here, because it will be a choice for the water undertaker to decide, well, do we want to treat this as a yearly expenditure in paying damages to the water body owner, which then diverts that money from something else we might do with it, or do we want to try and spend the capital in making the investment that's needed? But the public interest is exactly the same whichever choice they make, isn't it?
With respect, my lady's quite right. It provides an input into an economically rational calculus of whether or not investment makes sense or not. Of course, the other inputs into that calculus are the environmental benefits of any change. But I would make these 2 points in response. Firstly, the measure of any damage that is caused to individual property rights is in no ways necessarily commensurate with the cost of the works. It may be that very disparity that makes a case that the costs are excessive so very clear. Suppose that the effect of the pollution is to kill fish in a fishery once a year, and there are restocking consequences of that. It may be that that's measured in the tens or hundreds of thousands of pounds against works, the installation, let's say, of storm tanks that cost hundreds of millions of pounds. That may well provide the explanation for the relevant decision maker, which, by the way, is the Environment Agency and the Secretary of State, not Ofwat, as we'll see when it comes to the scheme. That may provide the relevant rationale for not doing the works, but it doesn't answer the point that this landowner is being expected to sacrifice that value in their land, either so that water bills are cheaper, or so that increased returns are made by private undertakers. And that is not a conclusion to which you should likely jump, that effectively my property rights are entirely surrendered in order that there should be cheap water or profits for water companies.
Well, the issue here is one of, we're not here to decide economic policy.
Of course.
I mean, if you had, for example, a victim of medical negligence, it might well be argued from the point of view of economic policy, it would make more sense for the health authority to spend the money on improving their hospitals than on compensating victims of their negligence.
Yes.
But under the law, they're under an obligation to compensate victims of their negligence. And normally, people who damage somebody else's property are under an obligation to compensate them for the damage to their property.
Correct, Manuel. Which is why we formulate the case by reference to the principle of legality. It's the principle of legality that provides the route to navigate through the relevant exercise of statutory construction to ask the question, has this right, this important right of nuisance to protect fundamental common law rights to property, has it been removed? That's the question for the court. And that's the question posed by careful construction of the legislation. I readily accept that once one gets into remedy, the court's very unlikely to be wanting to second-guess the views of the regulator that says that this piece of work is or is not necessary. And equally, I accept, maybe this will be MSC number 3, that if one gets into the question of what damages are payable, or whether or not there are user damages under the Morris-Garner approach or matters of that kind, that the law is sufficiently permeable at that stage to take into considerations of public interest. But we're not there.
Sorry. One of the reasons for distinguishing march change is that this is a discharge into a canal or a river. So it doesn't only affect the immediate landowner, it affects those downhill, downstream, inevitably.
Yes.
The remedy you're suggesting is paying compensation to the immediate landowner. How do you recognise the public benefit of the person downstream?
No, those who suffer harm downstream will have claims in nuisance. And that's the point made by Lord Justice Keane in the BWB case at paragraph 84 of his judgment, where he says the reason why the provisos are formulated as they are is to make it plain that there is a saving not just for trespass, which would be the immediate cause of action for somebody onto whose land the discharge occurs, but for nuisance, which captures the downstream rights. So, topic 3. The law in relation to remedies for property torts. I think we've covered that fairly extensively in the written case. The key point here is the development of the law of injunctive relief in the Lawrence case, which we say constitutes a very significant change in remedies. You have at one end of the, if you like, remedial spectrum, the extreme position painted by the speech of Lord Denning in the Miller and Jackson case, page 4558, where he describes the 19th century law on injunctions for trespass and nuisance, and where effectively those courts were granting injunctions at the drop of a hat in relation to any form of trespass. The law had probably softened by the time of Shelfer, but nevertheless, Shelfer constituted a very strong presumption that in a case of a property tort, where the nuisance was established, an injunction would follow. And that necessarily led to a risk of manipulating the lines of liability for fear that once liability was found, the consequence was that an injunction would be granted. Then we have Lawrence and Fern, which emphasise that, in fact, the grant of an injunctive remedy is a discretionary and unfettered exercise, and it is an exercise that will be informed by considerations of public interest. And under that case law, it is now, I would submit, very much easier to argue that an injunction should be refused because, let's say, the consequence of closing Davy Hume's treatment works that spill out into the lock just opposite Barton Lock on the Ship Canal would be to deprive most of West Manchester of sewage treatment services. It would be a fairly tall order to get an injunction in those circumstances. And the court now has the clear toolkit to make a principled refusal of relief. And we say that that is a material development in relation to the law on injunction. Can I now come to topic 4, which is ouster and immunity cases? Now, I think we all use ouster in the same sense, to mean the situation where one remedy is displaced in favour of another, typically another statutory remedy operating with a range of substantive or procedural conditions that make it more narrowly available. Immunity is at its core when your common law remedies are ousted and no remedy or no substitute remedy is provided. And the two concepts obviously shade into one another in what is, in truth, the spectrum. Now, the ouster cases start in their modern form. I think we're all agreed with the Child Poverty Action Group case, MSC 1152. And we've addressed it in the Allied Principles, sections 56 to 62 of our case. CPAG was a case grappling with the problem of overpaid benefits which had followed from an inflated official award, which award had been made not through any fault of the claimant, but because of a mistaken understanding of the law upon the part of the relevant social security decision maker. Once the mistake was identified and the award was set aside and adjusted, the question was whether the statutory scheme under Section 71 of the Social Security Administration Act limited recovery to those cases where the claimant was responsible for the inflated award, or whether or not a claim at general common law could be made for mistake of law, which would circumvent those conditions. There's a couple of points immediately to note about the case. Firstly, the ouster argued for and found was in fact very limited. It related only to unjust factors connected with the content of the award. It did not extend to mistakes of fact, such as accidental overpayments outside the term of the award. See paragraph 1, 1158 in the speech of Lord Brown. So the ouster in question went no further than was necessary in order to police the inconsistency. The second point to note is that the Section 71 remedy available to the Secretary of State for overpayment was of precisely the same character as the common law claim it displaced. It was in effect a narrower statutory restitutionary remedy available as of right where its limiting conditions were met. The third point to note is that the limitations placed on the right to recovery plainly had a protective character, designed to protect a financially straitened individual against the unpleasant consequences of having to repay benefits that had been overpaid and no doubt spent through no fault of their own. It was, in effect, a legislative judgment on the topic of whether or not there should be a defence of change of position. And by the legislation, Parliament had plainly said, yes, there should be. All this meant that when the question was asked, is that Section 71 scheme comprehensive, or must it be treated as being comprehensive? Because if you allow the common law to operate in parallel, you will circumvent that which Parliament desired. The answer was obviously yes. Because if you could just have recourse to a general restitutionary claim of common law for mistake of law, the statutory conditions would be rendered meaningless. Now, in CPAG, it was important that it was the state that was the claimant. Why? Because Mr. Eadie, as he then was for the Secretary of State for Work and Pensions, had sought to argue that a strict test of necessary implication should be used, because what was happening was the ouster of fundamental common law causes of actions to protect the right to property. And that argument was accepted on its predicates by Lord Dyson, such that that was the approach that would be required where common law fundamental rights were engaged. But it was rejected on its facts because the only claimant under Section 71 was the state. It was only the state that had this right of restitution in relation to state benefits. And the state effectively couldn't assert the principle of legality for its own benefit. You see that at paragraphs 29 to 31 in the speech of Lord Dyson, page 1167 to 8. And then one comes on to the test of ouster at 33 to 34, page 1169.
So you're saying this wasn't a case of taking away a fundamental common law right?
No, because it was the state that was the claimant. If the shoe had been on the other foot and it was a private law party seeking to say, well, the statutory scheme stops them from claiming that which I ordinarily would would be entitled to claim, the necessary implication argument would run. Now, the test used for ouster at 33 to 34 is formulated, I must confront it, by reference to Marchich. It's important to note that Marchich was cited simply for the broad shape of its reasoning rather than the detail of its application to the Water Industry Act. And the passage doesn't, in fact, address the point that had just been made, which is that it was a case involving the application of the principle, or should have involved the application of the principle of legality. And then paragraph 34 makes it plain that the operative question is whether the different approach to rights and remedies in the statutory scheme and common law meant that Parliament could not have intended that Parliament could not have intended that the common law survived, in effect, to second guess or circumvent the statutory regime. And so, by the very same logic, legislative indications in any scheme of legislation that the common law must survive in order to make the legislative regime work coherently must be equally fatal to ouster arguments. So where the structure of the legislation is to build upon or assume the continued operation of common law rights, that is the most powerful indicator against there being any form of ouster. Now, Marchich aside, all of the other leading ouster cases we referred to in our written case are cases of ouster in the context of a statutory regime for restitution or redress at the right of, or at the suit of, the party claiming restitution. And the question arose as to whether or not that statutory scheme ousted general entitlements in common law. So in DMG, for instance, the question was whether or not the statutory remedy in relation to a tax assessment ousted a common law remedy in circumstances where no such assessment was possible. And unsurprisingly, the court concluded that if there wasn't an effective remedy provided because there never had been an assessment, it couldn't be the case that the scheme operated to oust the operation of the common law in those circumstances. So the ouster was necessarily limited to a claim by reference to assessment. See, in particular, 996 at paragraph 19, Lord Hoffman describing this as an argument that goes much too far, and to similar effect, Lord Walker at 1034, paragraph 134. Total Network was a case about whether or not the statutory entitlements of the revenue ousted its ability to proceed against conspirators by way of unlawful means conspiracy in the context of a carousel fraud. And the argument, one can see just how unattractive it is that the only remedy that Parliament intended to subsist was the statutory remedy to pursue the missing trader that's disappeared or become insolvent for the VAT that's been spirited away in the carousel scheme, and that there was no remedy in unlawful means conspiracy against the parties sitting behind and acting in concert with the missing trader. And again, unsurprisingly, that argument was rejected, and in particular, it was rejected by Lord Mouse at page 1260, paragraph 130, on the basis that he suggested that what one had to look for was a positive, i.e. necessary, inconsistency between the statutory regime and the survival of the common law right, a test that was met in CPAG but not met here. And it was a test that had to be addressed defendant by defendant. So it may be that there was an ouster vis-à-vis the carousel fraud missing trader, but there wouldn't be an ouster as regards other defendants. And what is also conspicuous in that paragraph is the hostility to any analysis that leaves you without a remedy. Now, those are but the most prominent of the ouster cases.
Can I just going back to the child poverty case?
Yes, but
You've looked generally at ousting common law rights. But as I understood your argument, there is a more specific principle of legality when one is dealing with the ousting of fundamental common law rights. Now, where do we get that distinction drawn? Because I'm not sure at the moment that Total Network is talking about fundamental common law rights.
Total Network isn't, I'm sorry.
I'm rather assuming, from recollection, that nor is the child poverty case, for the reason that we talked about before, dealing with taking away fundamental common law rights. So these are just cases, are they on, does the Act take away common law rights, as opposed to the more, if you like, strident, fundamental, taking away fundamental rights, where the law is going to require something even clearer.
The argument in DMG was not formulated by reference to the principle of legality. It could have been. The argument of the Total Network wasn't formulated by reference to it, but it couldn't have been, because it was the fraudster effectively trying to invoke the statutory regime to set off the revenue's right of redress.
Well, fraudsters are the ones who are often most in need of the protection of their fundamental rights. So I don't think that just because it's a fraudster it means that their fundamental rights are more readily overridden.
I readily agree with that, my lady, but the point I'm making is that they were deploying the argument in order to hold on to that which was arguably not theirs, rather than to say, I have been deprived of a cause of action that will enable me to protect my property, and that is, with respect, different. But to answer my Lord Burrows' question, if one looks at 1166 and you see how the 1167, and how the argument is formulated by Mr. Eadie, effectively what he did was cite the principle of legality in Sins and to point to the fact that it applied to all fundamental human rights and to require necessary implication for any ouster. And that's then expanded upon over the page at 1168 by reference to the B. a minor case. And all of that is accepted by Lord Dyson, but then he says at 31, the context in the present case, however, is quite different. The question whether the Secretary of State can recover overpayments of benefit does not involve any fundamental human rights of the Secretary of State, nor does it engage the principle of legality. So what he's saying is, on the facts of that case, because the state was the claimant, the principle of legality doesn't arise. Nice try, Mr. Eadie, but you can't invoke the principle of legality to protect the state. So, Mark Chitch aside, you can see that these cases are concentrated on claims of statutory remedies of the same ilk being said to displace or not displace common law remedies. But when you start looking for ouster, in fact, you find it everywhere. You find it in the Autologic case, referred to by Lord Mance in Total Network. A competition lawyer finds it in the Day's medical case, in which it was held that common law restraint of trade was ousted by the statutory scheme of competition law, such that you couldn't second-guess judgments on whether or not agreements were in the consumer interest or not, reached through the statutory competition regime by use of restraint of trade law. And most importantly, you find it in the marriage line of case law, which I apologise we haven't cited in our written case. It's an important line of case law because it deals with the ousters that you infer from statutory authority and statutory compensation schemes. And as Mr. Karras, who is an expert in these matters, where I am most certainly not, this is probably a fertile area of debate in land disputes. Because what you do is you look to the scope of the relevant right of compensation that is provided for the statutory authority, and you use that to identify the scope of an ouster. So if the statutory regime provides for compensation in circumstances that align with the statutory authority, and the presumption is that they do, then that ousts the ability to make a claim at common law for the damage suffered in consequence. All you have is a claim for statutory compensation following the procedures that may be set out in the Act, whether it's arbitration or a claim to the Lands Tribunal, etc. So schedules providing for rights of compensation themselves work to effect ouster. And that's why the terms of Schedule 12 of this Act are important. And that's why it's important that the only compensation that the Act provides is compensation for activity within the scope of the powers. The Hall and Environment Agency case is a very good illustration of these principles. It's in Supplementary Bundle 8. It's a case involving statutory compensation under the Water Resources Act, the sister act of the Water Industry Act, in relation to the Environment Agency's flood management powers. And the judge, Mr. Havelock Allen, QC, reviewed the marriage case and case law, and in particular the speech of Lord Justice Jenkins. And in our submission, two short points emerge from the judge's compelling review of authority. The first is that the terms of the compensation scheme that are directly linked to and cast light upon the statutory authority that the Act confers are relevant, directly relevant, to the scope of the consequential ouster of claims. If compensation is merely provided for inevitable nuisances or actions that are lawful, the inference from the approach of Lord Justice Jenkins is that the common law survives to police that which is not authorised. And that includes that which exceeds the express conditions on the use of the power and that which is implied into them, i.e. the Allen and Gulfoyle implication against negligent use of powers, i.e. a use of power that doesn't take reasonable steps to confine the extent of the nuisance caused.
Where do we find that in the supplementary bundle?
It starts at 176.
It starts at 176. I'm most grateful to Lord Hodge. And the relevant analysis starts at 184, where the marriage line of case law is reviewed. The consequence in this case was that effectively the ouster married up with the terms of the compensation scheme. And that's unsurprising. You would expect statutory authority, ouster, and compensation to march in harmony.
But then the compensation scheme becomes, in fact, a limitation on the damage that somebody can claim. So it's in their interest to argue that they're not covered by the compensation scheme, perhaps because they can get more money.
It may or may not, my lady. It depends upon what is said about the substantive compensation that's obtainable in the compensation scheme. As it happens, in this Act, Schedule 12, paragraph 4 provides for full compensation for the damage suffered in consequence. Now, there may be other circumstances in which the statute directs some other measure of compensation. My lady's quite right that the measure of compensation becomes that expressly indicated by the scheme of the compensation regime in question. And that is one of the very reasons why a compensation scheme must operate to oust common law claims. Because, back to the CPAG reasoning, if it says that you can only get compensation for head of loss A, and the common law would provide you with compensation for head of loss A, B, and C, it would be inconsistent to circumvent that limitation on what you should be compensated for under the statutory scheme by recourse to common law. And that's why the three things, ouster, statutory authority, and compensation, march in harmony. Now, what these provisions also do, and you'll see this when we look at section 186 in Schedule 12, is that they provide for procedural ouster as well. They allocate...
Sorry, just before we leave that, Schedule 12, paragraph 4, only provides for compensation in respect of authorised
Correct,
discharges.
That's my point, then. Yeah. My point is that
And that's consistent with all the cases cited in Hall as well. It's where Parliament authorises an incursion upon private property, but it also makes provision for the payment of compensation.
And that's what's so very peculiar about this case, because the compensation right provided by Schedule 12 only applies to lawful exercises of power, and yet it said that which is ousted is the unlawful exercise of power. That's the point. That's the incoherence that this regime then creates. Now, the second point I was going to make about this line of case law is that ouster schemes of this kind are often a mix of substantive and procedural. It may direct a dispute to a particular place, and obviously by substituting common law rights with statutory claims to compensation, you're also changing things like limitation periods applicable under the 1980 Act. There's a different limitation period for claims of statutory compensation, matters of that kind. Now, those features are very important when we come to look at the terms of both Schedule 12 and Section 1863. Because when you look at Section 1863, you'll see that it is a limited, substantive and procedural ouster, predicated for its meaning upon the continued operation of the common law in areas outside its scope. Now, I'd suggest also that you see ouster and exactly this type of ouster reasoning in the plane of public law, where a statutory remedy, a statutory public law remedy, operates to displace judicial review. And the case of Crown and Wicks in the Supplementary Bundle 10, page 217, is the clearest example of this. It's a planning case. Mr. Wicks sought to contest his prosecution for breach of planning enforcement notice by saying that it should never have been granted in the first place. He sought to mount a Boddington collateral challenge in the criminal proceedings, and the House of Lords concluded that on the proper construction of the statutory scheme, his remedy lay in an earlier challenge to the making of the enforcement order, and that was his only remedy, and that chaos would ensue if collateral challenge was to be permitted, and the statutory scheme should be construed as ousting the general availability of collateral challenge in criminal proceedings. So that's a public law remedy, general remedy, judicial review, being displaced by a statutory appeal that does much the same thing. So again, remedies of the same ilk. What's truly singular about Marchidge, I would suggest, and again, we can find no other example of this, is that it entails an ouster of a universal private law remedy available as of right by a public law enforcement remedy at the discretion of another party, or at the powers of another party, a regulator, in circumstances where the remedy, if granted, an enforcement order, only does a small part of that which is done by the tort. It only preempts future trespass or nuisance. And yet it doesn't do anything whatsoever on the plane of compensation. And as a result, it cuts right across the rule in Firm that there should be no taking of private law rights without compensation. That's a factor that passes effectively unmentioned in Marchidge when looking at the exercise of statutory construction. Now, I would suggest it's one thing to say that a provision of a duty enforceable on the plane of public law does not prove that the breach of the duty gives rise to an actionable claim for breach of statutory duty. And one sees often, X and Bedfordshire and all that line of case law, arguments about whether or not the statutory scheme supplies an actionable breach of statutory duty, and very generally the answer isn't. There isn't one. And we'll see that one of the things that Section 18.8 of this scheme does is say certain terms. It basically says you shan't have a private law action for breach of statutory duty in relation to the Section 94 drainage duty. It's quite another thing to say that where you have introduced a new duty enforceable only by public law means, that remedy operates to exclude the pre-existing common law rights and remedies that arise independently and without proof of the breach of the public law duty in question. And yet that seems to be exactly the distinction that Section 18.8 is making, and it seems to be that category of case where you can state your case for nuisance or trespass without reference to breach of the Act, that is expressly preserved by the Act itself. Now, I would also make this point, that to provide only prospective public law-based enforcement mechanisms and to remove all mechanisms of compensation amounts to, or is very close in substance to, an immunity and all the consequences that brings, not least because...
Do you accept then that once an enforcement order is made, what happens to common law rights, trespass, if there is a breach of the enforcement order?
Well, what the Act says on that is section 22(2), which provides a limited cause of action for breach of statutory duty in those circumstances. And it's for damage caused by the breach of statutory duty, and it's not damage that is necessarily in any way connected with property or property torts. Let me give you a simple example.
Yes, no, I understand that, but do you accept or not that that does oust a nuisance claim brought by someone who is actually a landowner, but who would still have a Section 22 claim, but might have a nuisance claim as well?
No, my lady, we don't think it does. We think it is a supplementary action for breach of statutory duty available in those circumstances. That is most directed to things like this example. Your water supply is cut off for 4 months in breach of the performance regulations, etc. It's absolutely unacceptable that your water supply is cut off. An enforcement order is made requiring water to be reconnected to a business that will fail without the water in question. If you don't comply with the enforcement notice, I can sue for the economic loss flowing from the loss of water, and my business is destroyed in consequence. The damage isn't in any way related to or directed at property torts or property considerations at all. It's connected with the consequences of failure to comply with the enforcement order. So
you would just say it's a concurrent claim?
Yes. Yeah. Mark Chitch aside, I would suggest that the nearest case to grapple with the interface between public remedies and private law is in fact O'Reilly and Macman and the rule of procedural exclusivity it contains. And yet this is an area where time and time again this court and others have emphasised that if there is a true underlying private law problem, a party should be free to assert those rights and vindicate its rights through private law. And attempts to effectively displace the operation of private law by saying that it's a private law dispute with a public law element and therefore exclusively vindicatable through judicial review have failed time and time again. And once you appreciate that's the only case, it's pretty surprising because we've looked through the plethora of economic regulatory systems in areas like gas, electricity, telecoms, broadcasting, aviation, etc. We can find no other instance where a party's private law remedy for breaching their established property rights is ousted by the fact that you can complain to a regulatory authority which may or may not have enforcement powers of the kind one sees in this Act. And those enforcement powers are present in virtually every one of those regulatory regimes. Instead, what one has is concurrency of private law enforcement with public law enforcement. The only exception is where the law clearly confers an immunity. And there are instances of statutory immunity, and we've added one such to the bundle. It's the immunity in the Civil Aviation Act, Supplementary Bundle 6. Page 103. And the language of this immunity complies in starkest terms with the principle of legality. It says, no action shall lie in respect of trespass or in respect of nuisance by reason only of the flight of an aircraft over any property at a height above the ground, which having regard to the wind, weather and all the circumstances is reasonable. Or the incidents of such flight so long as, this is important, the provisions of any air navigation order and any orders under it have been duly complied with. So what this tells you straight away, that's what an immunity looks like. No compensation, no right to assert a claim in nuisance. And yet even here, the scope of the immunity is conditioned upon legality. You only get the immunity if you comply with the things that the law in the statutory scheme says you should be doing. So if you do everything but you breach the air navigation order, then an action in nuisance will continue to lie.
Okay, you said a moment ago that you've looked at lots of regulated sectors and
Yes.
found that there's no ouster of common law rights
Yes.
because there's a right to complain. Is that because common law rights are expressly preserved?
No, there is no,
No.
such express preservation.
So, to what extent are any of those regulatory regimes analogous to the water regime? Which of those are analogous?
They're all analogous to this extent. They all confer the kind of incidental powers that you need to go about doing your business. Indeed, I think my Lord Jones looked at this in the context of the Electronic Communications Code when a commissioner. They all contain powers to go and lay pipes or cables or ducts.
Yes, but we know what we know what the House of Lords based their decision on in Marchik. Is there anything equivalent to those considerations?
No, I don't think there is.
So there's not much we can gain from that comparison, is there?
I think there is in this sense. What I readily recognise is relevant is the capacity of the regulated activities to cause or not cause nuisance. And different regulated activities probably have different capacities to do so. Aviation is a good example where there's ample litigation, Rayner and all that case law about aviation nuisance. Other areas, telecoms, maybe less so. The nuisance or trespass that arises in those cases is in connection with the exercise of special powers like pipes and ducts and those things. But again, those are the cases that generate statutory compensation schemes, providing for compensation for the lawful exercise of the power, that also leave unousted the claim in nuisance or trespass in circumstances where you've exceeded your powers. And I don't think one can underestimate, laying a large pipe or duct or cable has a real capacity to cause substantial nuisance to the person on whose land it's situated, particularly if you're talking about high voltage electricity cables and matters of that kind. So this section of the CAA is, I would suggest, a good exemplar of what you should be looking for if an immunity is conferred. But as we'll see, UU's case, in fact, has to go much further. They have to argue for an implied ouster amounting in substance to an immunity, Dobson, negligence and intent aside, first, despite the fact that there is an express ouster provision in the Act. That's what Section 18.8 is. I'll show you why I say that momentarily. And that express ouster plainly operates to preserve a claim like the claim in the present case. That's their first forensic problem. The second forensic problem is that the provisos have no meaningful role at all, other than to show that Parliament intended certain statutory powers to be limited in scope and for ordinary common law rights of enforcement to continue in parallel where the powers were exceeded or where the questions that were referred or ousted, in the case of Section 186, built upon and ran alongside the common law. And the third forensic problem they have to address is that of compensation, because there is no compensation, and that militates most heavily against this. So where that review of ouster authority gets you to, I would suggest, is the following combined principles. The foundation of ouster, of a common law right, and its remedies, is ultimately some form, some strength of positive inconsistency with the regime of rights and remedies contained in the statute. And conceptions like circumvention of safeguards are important tools to articulate that by. The question as to whether or not there has been ouster is to be answered by reference to the statute as a whole, and in particular by reference to the scheme of rights and remedies it contains, the inconsistency they may generate, and then what the statute itself expressly speaks to about the continued role or operation of common law rights. Now, in investigating that topic of inconsistency, I would suggest three things are particularly important. The first is the nature and extent and implications of the inconsistency, and whether or not the common law action will circumvent, undermine, or weaken protections or procedures required by Parliament. Secondly, it requires a consideration of remedy and its adequacy, and that must be in particular where the principle of legality operates to focus upon compensation for infringements of property rights. And thirdly, it requires a consideration of coherence. Does statutory authority, remedial ouster, and compensation march in harmony as they should? Or does the statute clearly provide that which would otherwise be exceptional, which is full private law immunity for action which is contrary to the statutory scheme itself? Now, here, I think the answer to the question posed earlier by my Lord Burrows comes in, because what the principle of legality does in our submission is inform the intensity of scrutiny in relation to each of those questions. It informs the type of inconsistency you're looking for. Is it inconsistency by necessary implication? It informs the intensity of review about the adequacy of the remedy. So we've seen already from Fern, if there's no compensatory remedy provided, that's a big alarm bell. And lastly, informs the considerations of coherence, because Parliament should be expected to legislate in a coherent and consistent fashion by reference to fundamental common law rights. The last thing to notice is the test is granular. It requires you to look at each claimant or potential claimant. We saw that in the total network case. And by logical extension, it requires you to look at each form of remedy under consideration, here injunctions or damages, or each prerogative remedy in judicial review. And then finally, and this is a topic I would suggest that this case illustrates hasn't been explicitly grappled with hitherto. It raises the question as to what you should look at first. Should you look at, in a scheme of legislation, a general duty? Or should you look at the specific conditions or limitations placed upon the use of powers that are made available in order to discharge that general duty? The approach in Marchich was only to look at the general duty, because that was all that was before the court. The approach below has been to look at section 94 and the general duty first, and then to ask if the provisos add anything. And in my submission, that is the wrong approach in relation to ouster analysis. When you are dealing with the terms of the Act that govern and limit statutory authority, that is, authority to do that which would otherwise be tortious, the necessary first starting point is with the detail of the specific conditions that regulate the power that authorises you to do what would otherwise be tortious, not the general duty. And there is a very good illustration of this in a recent decision of the Court of Appeal, the case of Piggott and the Environment Agency, in which Lord Justice Nugent sat 18 months before deciding the appeal in this case. My Lord Richards will recall the case, having been on the panels. And it's a case in many ways similar to the present. There was a general duty.
What's the reference to that?
Page 3178, it's Authorities Bundle 8, page tab 83. There was a general duty under the Salmon and Freshwater Fisheries Act to protect salmonids, and there was a specific power to build fish passes, and that specific power to build a fish pass was subject to a condition that the construction and operation of the pass must not affect the milling power of the river. And the dispute was between a mill owner who said, in effect, too much water is going over the fish pass, my mill has lost its milling power, you're in breach of the limiting conditions of the statutory power, and therefore I should be free to bring a claim in nuisance against you. And all this was, like this case, ventilated through Part 8 proceedings. The Environment Agency, by contrast, said no, the claim must fail because the exercise of the power in this way, by discharging excessive water, was the only way that they could discharge their duties to protect salmonids, to get salmon up over the pass and spawning in the river above. The Court of Appeal agreed with the claimant that the Environment Agency could not rely upon its general duty to defeat the claim that would otherwise arise from the excessive or unpermitted use of the power to build a pass. If the Environment Agency exceeded the limits of the power, the claimant was entitled to claim in nuisance. See paragraph 68, page 3197, in the speech of Lord Justice Nugent. And if that's right, it means the starting point in this case is an analysis of the particular powers in this case, the section 116 implied power of discharge, subject to the conditions in section 1175, not an analysis of the general position under section 94 of the Water Industries Act. It basically says you start with the particular and it's not answered by the general. And we would suggest that not only is that a matter of authority, it's also right as a matter of logic. It's right as a matter of logic because the whole point about terms and conditions on authority, about limiting conditions that say you have authority to do this but not that, and confining powers, is Parliament is engaged in an exercise in explicitly identifying that which is impermissible and therefore tortious, if tortious without a statutory authority. To fall back in those circumstances on a general breach argument and general remedial provisions has the effect of ignoring the clear limitations placed upon the use of the powers to achieve the aims of the duty. And what's more, we'll see that that is the stance advocated in terms by section 94(4) of the Act, which says in terms that arguments about breach of section 94 shall effectively be without prejudice to other remedies that may arise under other parts of the Act connected with the breach of the terms of the powers it confers. So with that run-up, can I then come to the meat in this case, which is the Act. It's the detailed terms of the Act that's the guts of this case. Complex, I think, is a lawyer's polite euphemism to describe the density of this Act. And I'm going to have to take it slowly because it's one of those sources of legislation where more emerges on the second, third, fourth or fifth reading that just doesn't jump out first time round. To assess the case for Ulster, we're also going to have to look at all of the provisions as a coherent whole. And the provisions start with the very important terms of Part 1 that sets up the Water Services Regulatory Authority, Ofwat, and equips it with general duties in its Section 2. And this technique in the field of economic regulation of general duties is, again, as I'm sure my Lady Rose knows, entirely common in the regulated sector. So you see these general duty sections for telecoms, gas, electricity, all the regimes adopt this approach. And Section 2 sets out at 2A, page 678, Ofwat's key duties. And the key duties show that it is principally an economic regulator, not a regulator connected directly with environmental protection. Indeed, the only place you'll find any reference to the environment in Section 2 is in Section 2DA in describing the resilience objective. And it's not a freestanding obligation of environmental protection. The objectives are A, to further the consumer objective, and that's explained further at 2B and 2C. B, to secure that the functions of a water undertaker and of a sewerage undertaker are properly carried out. That's an important term, properly carried out as respects every area of England and Wales. C, to secure that companies holding appointments are able, in particular by securing reasonable returns on their capital, to finance the proper carrying out of those functions. So the financing is consequential upon the proper carrying out of those functions. And D, to secure that the activities authorised by the licence and any statutory functions imposed on it in consequence of the licence are properly carried out. And it's that D that sits behind the enforcement provisions.
It's perhaps worth just making the observation that although the protection of the environment is obviously an aspect of what we're concerned with here. It's by no means the only aspect. For example, a canal owner might want to use its canal for leisure purposes.
Yes.
It might want to develop facilities along the banks for cafes or the like. I mean, I don't know. There are all sorts of potential economic benefits of being a canal proprietor besides the passage of ships up and down the canal,
Yes.
which might be affected by pollution of the canal.
Absolutely. And if that's less obvious in the relation to an industrial canal with banks 30 feet high, it's very obvious in relation to a pristine stretch of the River Test, which you might exploit for fishing or walking or whatever reason, or canoeing. There are many forms of exploitation of amenity value inland that are protected by the torts of nuisance and trespass. That's the whole point. Go back to the case of Smeaton and Ilford, and it was a case about the stench of the sewage affecting the pleasure gardens that the relevant sewage ran through. People didn't want to go to the pleasure gardens because they stank. So, absolutely, my lord. Then there are subsidiary duties in section 2.3 that are downstream to those in 2A of economy and efficiency, no undue preference, sustainable development, no mention of the environment as a freestanding consideration or amenity value. And then the provisions of 2.6 are important to understand what's going on, because it tells you what the statutory functions are and therefore what the scope of potential enforcement under section 18 is. The statutory, it says at 6, page 681, subject to 6A below, the reference in subsection 1 to the relevant provisions is a reference to provisions contained in Part 2 of this Act. That's us for present purposes, because section 116 is in Part 2. And then any of sections 95, 95ZA, etc. So you can see that the relevant duties are relevant insofar as they arise to all of Part 2 and to Ofwat's role in relation to any regulations the Secretary of State makes under section 95. And then there is a definition of the relevant statutory functions. I've lost my reference. Come back to that. I think I'm confusing the provision. I think it's actually in section 18. So that's the scheme of section 2. And one can readily see how the interests identified in 2A might appear to be in some tension. You can see how considerations about how the proper discharge of the statutory functions might be generating tension in terms of cost for the consumer objective or the ability to generate reasonable returns. But what I suggest you can't do is read section 2A D in its reference to the performance of the statutory functions and ensuring they're properly carried out as authorising something or condoning something that is not just improper but also unlawful. The requirements of a legal duty to do X, Y or Z cannot be expected to give way to the fact that the consequence of that is cost to the consumer or the financiers of the relevant undertaking. And the Lancashire case, which we'll come to, confirms as much. Then you have sections 11 to 12 at page 689. It's these elliptical provisions that confer on Ofwat the powers that are almost entirely extra statutory to regulate the charges that may be set under section 142 and 143 of the Act. And unlike in some schemes, where you see the meat of the licensing scheme in the Act itself, here it's effectively Ofwat's ability to set conditions of appointment and to set in its discretion the 5-yearly investment plans, etc., that then inform the charges that will allow, that drive Ofwat's role as an economic regulator. All of that is subject, in many instances, to a potential appeal to the Competition and Markets Authority, if effectively, in relation to an issue like price control, the terms of the appointments say, as they invariably do, that a dispute on this issue can go to the Competition and Markets Authority. And that tells you that sections 11 to 12 and the entire scheme that authorises is effectively the regime of economic regulation in which Ofwat engages. And you've got Mr. Hazlitt's very helpful evidence explaining the 5-year cycles, the controls on OPEX and CAPEX and all of that matter. That is all squarely and exclusively within the process controlled by sections 11 to 12. Then you come on to Part 2, Chapter 2. So after Part 2, Chapter 1, which is headed Appointment, you then have Part 2, Chapter 2, headed Enforcement. And it's in that part of the Act that Section 18 appears. And the key thing to note initially here is that this is a duty to enforce. You get as much from page 698, the heading to section 19, exceptions to duty to enforce. You also get it from the language in 18(1)(a)(1), because where a company holding an appointment is to Ofcom's satisfaction, A, contravening, then look at Roman 2, any statutory or other requirement which is enforceable under this section, and in relation to which Ofwat is the enforcement authority, Ofwat shall, not may, shall, by a final enforcement order, make such provision as is requisite for the purposes of securing compliance with the condition or its requirement. So it's a scheme of, if X occurs, you shall do Y. You have to show the contravention of a statutory requirement, and that is defined, and it was the bit I was looking for earlier and I got lost, at page 696, subsection 6. For the purposes of this section and the following provisions of this Act, the statutory and other requirements which shall be enforceable under this section shall be such of the requirements of any enactment or subordinate legislation as are imposed in consequence of that appointment and are made so enforceable by that enactment of subordinate legislation. And what in layman's terms that tells...
We're looking at little 2 here. Is that the one that's relevant for us?
Yes. And the relevant source of statutory requirements here is either section 94 or following of the Water Industry Act, or, as we shall see, regulation 4 of the Urban Wastewater Treatment Regulations. What is not encompassed as a statutory requirement is the environmental permitting regime operated by the Environment Agency. Ofwat has no powers to enforce environmental permits. Equally, Ofwat has no powers to enforce the provisions against statutory nuisance in the Environmental Protection Act 1990. Its powers are confined to breaches of the statutory requirements in the Act.
What is the accountability regime for Ofwat if people think that Ofwat is not complying with this, as you pointed out, mandatory duty to enforce these statutory requirements?
Judicial review, my lady. And we have an example of such a judicial review in the supplementary bundle. So far as we can see, there have only ever been 2 cases directed at judicial review of Ofcom's enforcement functions.
Ofwat,
sorry. Sorry, too many offs in my headspace. It's tab 9 of the supplementary bundle, page 193. And it's Crown against Ofwat, ex parte Lancashire County Council. This is a case that looks at section 18 and 19 in terms and grapples with the question of whether or not Ofwat can sanction unlawful conduct. The only other case is about the Thames Tideway Tunnel, which was about the effect of undertakings. duties. And I don't think it sheds much light
But
on...
isn't there some political accountability, which is the department which can call Ofwat to account through a committee or something like that?
I don't believe that that would amount to either a statutory remedy or part and parcel of the structured requirements of the Act itself. And we're looking in the Act for the answers to how the Act contemplates this regime should work. So, with respect, we don't think that you can look, as we said in our written case, to the detail of the Ofwat regime, which is non-statutory, to provide the answer to the question of ouster. So you have a duty to take action in certain circumstances. You have a narrow definition of statutory requirements. And then you have the exceptions made to the duties to enforce in section 19. But before we get to that, we must look very carefully at section 18.8, because in our submission, this is perhaps even the critical provision in this case. Why? Because when you look at it, this provision is an express ouster rule. And what UU is seeking to do is to rewrite the terms of this express ouster rule by implied ouster. What 18.8 says is where any act or omission, A, constitutes a contravention of a condition of appointment under Chapter 1, or a condition of a licence, or a statutory or other requirement, so that's the relevant language, enforceable under this section, or B, causes or contributes to such, the only remedies, so that tells you you're talking about ouster, the only remedies for causing or contributing to that contravention, apart from those available by virtue of this section, again, it tells you we're talking about ouster, shall be, and then put a little 1 after B, those for which express provision is made by or under any enactment, that's the first category of exception, or 2, those that are available in respect of that act or omission otherwise than by virtue of its constituting or causing or contributing to such contravention. So there are 2 categories of exception to a rule of general ouster of claims formulated by reference to the duties. The first is where you can make your claim under another statute. The second is where you can make your claim without referring to the breaches in the Act. And that means that this provision does 2 things. It firstly says very clearly there is no action for breach of statutory duty. And secondly, it is an express ouster rule because it tells you what the effect of section 18 remedies is upon other remedies. And you've got those 2 categories of exception. Now let me give you some examples of cases falling within those exceptions. If the EA pursues somebody for a permit breach under the 2016 regulations, that is a claim formulated with no reference to the WIA at all. It's formulated by reference to the terms and limits in the permit. You breach the permit, strict liability offence, that's a claim in the first category, perfectly permissible. Equally, we'll see, it captures abatement proceedings under the 1990 Act, available to every single local authority in the land, indeed a matter of a duty of investigation and a duty to take abatement proceedings when a nuisance is identified. Those proceedings fall within the first category of exemption. The second category of case is exemplified by our case. It's any case where you can plead your case, you state your case, without formulating it by reference to breach of statutory duty. So nuisance and negligence, trespass can all be formulated in that way, and that's entirely consistent with the second category of claim. What you can't do is pray and aid in your case the heinous fact that by doing these things, they've also breached their duties under the Water Industry Act. That's the forbidden territory. So what you couldn't do, for instance, is construct a claim for unlawful means conspiracy, where the unlawful means relied upon was breach of the duties under the Act. That would be impermissible. Now, we fall squarely within that second category. The claims in nuisance and trespass here are all entirely statable and were stated in the 2010 proceedings without any reference to the duties under the Act. So what must be going on is that UU is driven instead to rewrite the terms of that express ouster and to say, nevertheless, you should infer that the claims are still ousted, even though 18.8 says otherwise. And that's an argument that runs against the express grain of section 18.8, which, however you cut it, is the governing ouster rule. And it's an argument that has to grapple with the fact that by an implied term, you're trying to rewrite the express, which, just to give a contract analysis, is obviously impermissible territory. You can't use an implied term to subvert the express term of agreement. You can't do the same with the statute. And it's also got to grapple with the fact that this implied ouster is to arise in a case where the consequence is the engagement of the principle of legality, because the right that's been taken away by implication against the terms of an express ouster rule is a right to vindicate private law property claims. It's like arguing for an implied term saying A when the express term says not A.
Now, can I just be absolutely clear what you're saying about the last part of 18A, those that are available in respect of, etc. You're saying that that rules out a claim for breach of statutory duty, and it rules out any other claim that you would have where you need to rely on the breach of statutory duty to make that your claim.
Correct. So any claim where a necessary constituent element of the claim is breach of statutory duty is debarred.
And the example you gave us was the unlawful means,
Yeah.
conspiracy, or
Yeah.
whatever it might be. Yeah.
Now, I am going to jump ahead a little bit here, because one of, I'm afraid, the unsatisfactory aspects of Marchich is how section 18.8 was grappled with by their lords in that case. Lord Nichols merely cited 18.8 at paragraph 14 and recorded Mr. Hockman, who was counsel for Mr. Marchich's argument at 22, that his claim in nuisance was within the second category of accepted case. And having done so, he said nothing more at all about 18.8. Lord Hoffman went further and accepted at 52 and then again at 54, page 1142, citing the Baron and Portslade case, he accepted that the ouster rule did not bite on the claim so formulated, but then effectively went on to find an implied ouster in the rest of the Act, notwithstanding the terms of section 18.8, with which his speech did not grapple. He simply didn't engage with the point that he was rewriting the ouster rule. And surely any argument of construction for implied ouster must first of all explain why something as substantial as rewriting the express ouster clause to say the exact opposite is a necessary implication. Can we then look at section 19?
Just before we do, it occurs to me that in relation to the duty placed on Ofwat, it may be relevant to mention that we're hearing an appeal later this year where the argument is that a public authority which is subject to a statutory duty should not be subject to having that duty enforced by a mandatory order because it simply doesn't have the resources to carry out the duty, to perform the duty. It's a more general problem, perhaps. The case is actually brought against a local authority.
Is it in the context of homelessness?
It is. It's
Yes.
in the context of homelessness.
Yes. Well, it's a familiar problem, but unfortunately, the statute does what it says. It requires what is to be done. The question of an appropriation is a question for Parliament. But in my submission, that's not a problem here, because there is no inconsistency between full enforcement and economic regulation. Why? Because if sufficient funds haven't been provided in the course of economic regulation, the appropriate course is for the regulated party to ask for more funds to do that which the law requires them to do. And the consequence of that is higher bills for consumer,
to ensure that the water is not polluted, and maybe diminished returns for the undertaker if it's not allowed to recover the full cost in question. None of those factors justify rewriting the legal obligations we'll see that this regime is built upon.
But you saw in section 2 that their duties are also to take into account the needs of people on low incomes.
Yes, my lady. Yes. Yes, so long as consistent with other functions. Can I just show you 19, and then I'll show you the Lancashire case, which I think goes to the concern my lady's articulating. These are the exceptions, page 698, to the duty to enforce. They're contraventions which are of a trivial nature. That's A and AA. There's an exception if the person in question has given an undertaking to take such steps as are necessary to secure compliance. And the effect of an undertaking is then described in 19.2, and it becomes effectively another statutory requirement. So if you breach an undertaking, the regulator then has to turn that undertaking into an enforcement order before the damages provisions are triggered. And then C, the critical one, the duties imposed on him by Part 1 of this Act preclude the making, or as the case may be, the confirmation of the order. Now, the Lancashire case grappled with precisely that issue some 3 or 4 years before Marchedge, though it wasn't before the House of Lords in Marchedge. You can see the storied talent lined up. Mr. Howell was for the County Council applicants.
Are we in the bundle?
Supplementary bundle, tab 9, page 193. I'm looking at 196. Mr. Turner, a noted expert on water law and economic regulation, was for the authority. And Mr. Panic, QC, as he then was for the directly affected parties, i.e. the undertakers. Of course, appeared in Marchedge. And the issue in this case was effectively, amongst others, whether or not the requirement to comply with a legal duty trumped considerations of consumer or other interest. And Mr. Justice Harrison concluded in terms at 212 through to 213 that it did not. And in particular, the material passage is at 213. Section 19(1)(c) only exempts the director from his duty to make an enforcement order if he is precluded from doing so by another duty imposed on him by Part 1 of the Act.
Sorry, whereabouts in the
Page 213, about halfway down in the paragraph
yes,
starting
yes.
in my judgment. Any contrary conclusion would have the effect of allowing the director to dispense with the performance of obligations under the statutory code relating to disconnections, i.e. the relevant statutory requirement, which cannot have been intended by Parliament. I therefore conclude that section 19(1)(c) does not entitle the director to refuse to take enforcement action under section 18(1). And what that means is that where the director is confronted with a duty that is being breached by the undertaking, it is no answer to point to considerations of cost or consumer benefit to answer the breach of the law or the duty to enforce. The relevance of this is, I'm afraid, that I think the extent of the discretion arising in the connection with the questions of enforcement rather than licence condition in Marchedge is overstated. And that the role of the director in relation to enforcement is more trammelled where you are dealing with something that is an excess of powers, something that is contrary to statutory requirements. And that, we shall also see, aligns fully with the approach to abatement, where local authorities, considerations of resource notwithstanding, have a duty to investigate statutory nuisances and a duty to require their abatement. So that's sections 18 and 19. Section 22 we should look at very quickly. That's the provision that provides the concurrent cause of action for breach of statutory duty where you've breached the undertaking, page 705.
It requires the breach of the enforcement order. A breach of an undertaking won't suffice. And that, of course, means that even where an enforcement order is made, you will get no redress for any loss or damage occurring before the making of the enforcement order. It means that if the question is resolved by undertaking, you will have no concurrent right of statutory action. And it means, most obviously, that if no order is made, you have no remedy for breach of statutory duty at all.
You don't really need one. Well, you don't need one, you would say, if you're a landowner.
Exactly. Exactly. So the benefit of 22.2 is principally for those who, absent it, wouldn't have a cause of action. Now, we would suggest that the result in Lancashire is obviously right. It complies with the requirement of legality at the end of the day, not the principle of legality, the requirement of legality. Anything else effectively turns section 18 and 19 into a dispensing power, the kind of thing that we fought the last English Civil War about, where parties are released by regulatory diktat from the requirements of the law set by Parliament.
I do apologise, but you took us to the supplementary bundle at page 213.
Yes, ma'am.
For the proposition that section 19(1)(c) does not entitle the director to refuse to take enforcement action under section 18(1). And I'd be grateful if you could explain the reasoning a little bit more fully as to why that is so.
The reasoning is this, my lord. Effectively, where the proper function is a requirement required by law, in other words, where it's a duty, nothing in the scheme of section 18 or in section 2 releases you, the enforcer, from the duty to enforce the duty being breached, unless so to enforce would give rise to another concurrent breach of some other statutory duty.
And the statutory duty here is in section 2, yes?
In this case, the statutory duty in this case arises from a host of sources, not just section 94, but also regulation 4 of the urban wastewater treatment regulations, which I'm going to have to show you in due course. And that's the duty, a very clear duty, fleshing out regulation section 94 to provide for adequate collection and treatment systems.
Mr. Justice Harrison said the only balancing which is allowed under section 19(1)(c) is a balancing between two clear breaches of statutory duty, not between a clear breach of statutory duty on the one hand and on the other your discretion as to pursuing your other objectives in a broader
Correct.
way. That's
Correct. The priority is, first of all, compliance with the law.
But doesn't section 19(1)(c) bring into play the duty, the general duty, admittedly, under section 2(a)(c)?
It does, but what's required is to show that the breach, that the relevant consumer interest duty would be breached. That's what's required. You need to be able to set up something that is incontrovertibly itself a breach of some other duty owed by offenders. That's the reason why we say the forensic noose tightens, and may tighten very substantially when you begin to grapple with the nature of the particular breach at issue. Not least because, as we'll see, under the 94 regulations, the party charged with making judgments about cost is either the Environment Agency or the Secretary of State, and it's not Ofwat at all.
Well, how then, in such circumstances, is effect to be given to the general duty under section 2(a)(c)?
It's given effect to by securing that the mode chosen to end the contravention of the law consists and complies with that duty so far as it can. So you keep costs to bring about the breach to a minimum. You may need to, and it may redound to the undertaker's benefit, because it may give them a basis to say, well, since we have to do this thing to avoid the breach of our duty, and because it hasn't been financed, you, Ofcom, must revisit the charging that we're entitled to administer so that we're paid for doing it. That's how it redounds. It doesn't redound to excuse a breach of the duty altogether, which is, I think, how the House of Lords read it in March, wrongly in my submission.
But that's a very considerable limitation
It is.
on the power of the regulator, if you're right.
That's right, I accept that. But that goes back to the point I was making, that the locus of the real discretion of the economic regulator is in the section 11 and 12 process of charge setting and payment. And the job they have is to ensure that what is being done efficiently by proxies to competition, because obviously they're all statutory monopolies, and that the payment being sought for doing that which is required is proportionate, reasonable, etc. And of course, as part and parcel of that, they take account of what the EA and the Secretary of State say on the topics of BT, K-NEEC and excessive cost under the regulations, as I'll show you. But that's why I say, I hope transparently and straightforwardly, that the picture of regulatory discretion that underpins Marchage is perhaps exaggerated to a considerable extent. It's not quite the open-textured balancing of duties that you would take away, and that you need to confront the issue seen in the Lancashire case to understand how narrow or wide it is. And obviously, the narrower it is, the less scope for conflict with the common law remedies. Section 94, then, page 726. Can I try to get through this before lunch? I imagine you've pored over it. Section 94, 1A is what the community law regime calls the collection systems part. It's getting wastewater into sewers, etc. Section 1B is the treatment limb. It's the emptying of those sewers and the provision of further infrastructure for effectually dealing by means of sewage disposal works or other with the contents thereof. So A is collection, B is treatment. And of course you get outfalls or discharges from both CSOs, which are part of the collection system, and the wastewater treatment works, which is the treatment section. It's notable how very widely drafted the duty is. It was the width in particular of 94.1b that created the problems in the Dobson case, because the argument the authorities made was, well, it even encompasses whether or not we've netted off the tanks or whatever to stop mosquitoes. That's a part of our effectual dealing with the sewage and therefore falls within the scope of the Marchage duty. 94.2, duty of the sewage undertaker in performing its duties to have regards to future needs, to plan forward. And then 94.3, this tells you that this is enforceable under Section 18 by Ofwat, so it answers the question as to who the relevant enforcer is back in Section 18. And then 94.4, this is very important because this confirms the Piggott analysis. You start with the particular rather than general. The obligations imposed on a sewage undertaker by the following chapters of this part. So we're in Part 4, Chapter 1. The following chapters are Chapter 2, which contain a good deal of the relevant sewerage provisions, and the remedies available in respect of contraventions of those obligations. So that's section 116 and 117 for our purposes, shall be in addition to any duty imposed or remedy available by virtue of any provision of this section or section 95 below, and shall not in any way be qualified by any such provision. Now that section is effectively adding a third category to section 18.8. It's a third tempering of the express ouster rule that says if other parts of the Act contain other remedies, and we would add parenthetically, including other remedies necessarily predicated or built on the concurrent application of the common law, then those remedies are not in any way qualified by section 94. And that is the clearest legislative indication that discharge cases require a separate and different analysis to escape cases, because you need to find the answers to discharge cases in Part 2. And if that's a convenient moment, that's where I'll come back to after lunch.
Sorry, your final point was noted, so discharge cases are not covered by...
Discharge cases, to look at the scheme of remedies that Parliament intends, you go to Part 2 and you look there first before coming back to section 94? So it's the priority issue. Do you start with the particular powers and their limits, as we say, or do you start with the section 94 duty, as the Court of Appeal and UU says? I appreciate I'm going at a cracking pace.
What do the words "any such provision" at the end of 94(4), what is that referring to? Any such provision where?
In paragraph, in chapter 1 of this part, or section 95. So it's any provision of this section or section 95 below. So it tells you any such provision in section 94 and section 95, and shall not in any way be qualified by section 94 and 95. And section 95, which we'll come to after lunch, unless it's convenient for me to address it now, is the provision dealing with regulations.
I'm afraid you took it a bit fast for me. Why do you say that the implication of this subsection is that discharge cases require a different treatment from escape cases?
Because the terms and conditions and the remedies provided in relation to discharges are dealt with in a later chapter. They're dealt with in chapter 2 and not this chapter, chapter 1. And they don't arise in connection with section 94 or 95. They arise in connection with the sections in the later chapter.
Thank you very much. Well, we'll adjourn now and resume at 2 o'clock.